with the extra curial statement of accused number 2, which implicates accused 3, 4, and 5. In England, they use the term out-of-court statements. Paragraph 8.1, we mentioned, my lord, that accused number 2 made not one confession, but 2 confessions. One before a commissioned officer, Lieutenant Colonel Rapadu, on the 19th of June 2020 at Moroka Police Station, and the second confession before Magistrate V. Cronje at Boksburg Magistrate Court on the 24th of June 2020, in the presence of a legal practitioner, Mr. Mjiako, who was an attorney at the time.
So in this video, we are going to go over the dreaded confessions. Yep, the ones that the state are holding on tight, the ones that my lord entered into the record provisionally. Actually, somebody asked me in the comment section to explain what that meant. I believe, let me see if I have the comment, because I think it was a great comment. I think it was a great question. Okay, so they had quoted, they had put a timestamp on my previous video where Judge Rata, and the comment says, "What does Rata mean at the 13-minute mark? Please help, English is hard." And of course, I'm happy to help. So the judge in that video had said, I made 3 rulings and those are interim judgments. And I explained what interim judgment is. Interim judgment means the confessions have been added into the record interim. Part-time, yeah. They've been added part-time. So he's talking about the ruling that he made in a trial, within a trial, to admit the confessions. When he says interim, it means he didn't make up his mind 100%. As the trial continues, he is willing to change his mind based on new evidence that comes to play that will help convince him to make a solid final decision. So he hasn't made his absolute final decision on the confessions, but we know he's at 95%, okay, based on his behavior. So to say the confessions were not taken freely and fairly so that they are no longer admissible, that is going to be the hard hill that the defense have to climb throughout their defense case. In summary, the judge can still throw out the confessions at any time. So I hope this response also helped somebody else who was wondering about the confessions. So yeah, these are the confessions. So Baloyi is now breaking down the confessions, and he begins by giving us that Ntanzi wrote 2 confessions. Well, gave 2 confessions. One was with Lieutenant Colonel Rapadu at the Moroka Police Station, and the second one was with the Magistrate V. Cronje, who happened to record everything on her laptop, but that record was not allowed to be played in court because who really knows what's there. But the purpose I stopped this clip here was to say, Baloyi says the second confession was taken before Magistrate V. Cronje at the Boksburg Magistrate Court in the presence of Mjiako, who was an attorney at the time. I thought that was quite significant that he puts that on the record. So let's continue listening on and see where he goes with that point.
And in the latter confession, he starts the confession by mentioning that he worked in Carltonville in 2014. This fact, my lord, is corroborated by his clocking records, Exhibit DD, and the evidence of the HR manager, Mr. Miller, who has testified in this proceeding. So, my lord, there's that safeguard of the truthfulness of what accused number 2 says. It is a fact that he works at the place mentioned in the confession, in the Carltonville mine, and he did take the police officers to his place of employment. In paragraph 8.2, he states further in the confession that he received a call from Sifiso Ntuli, who is accused number 5, to come to Basotho Hostel after accused number 5 had obtained his number from Muzi, accused number 1. He proceeded to Basotho Hostel, and Sifiso, accused number 5, called him to a room wherein Muzi, accused number 1, and Sfiso, accused number 4, where accused number 5 then told him that there was a job to be done that evening. Then in the confession to Lieutenant Colonel Rapadu, he said that he was briefed that the person to be eliminated or killed was SENZO MEYIWA, and that the matter was initiated by Kelly Kumalo, who was going to make payment for the whole job. Mapisa, accused number 4, was to be positioned outside as a backup. Surveillance was then conducted. They were initially in the room of accused number 1 and later proceeded to the room of accused number 5, where they were joined by accused number 3, Karos, and Ntokoziseni Mapisa, accused number 4, who is now applying for Section 174 discharge. 8.3, he mentioned further in this confession to Ms. Kronye that Karos, namely accused number 3, and Ntokoziseni Mapisa, accused number 4, called Kelly Kumalo. They told her that they were ready. They all left in a Polo Vivo driven by accused number 5. It was himself, that is accused number 2, Karos, accused number 3, Mtokoziseni, accused number 4, and Muzi, accused number 1. And to Lieutenant Colonel Rapadu, he said it was on a Sunday between 1900 hours and 2000 hours that Ntokoziseni Mapisa, accused number 4, Sfiso, accused number 5, they came across another Polo Vivo driven by one Simpiwe, that they all alighted except himself, that is accused number 2. Simpiwe gave Ntokoziseni, accused number 4, 2 firearms. They then left for first arrest and proceeded to the address. A call then came through to Karos, accused number 3, presumably from Ms. Kelly Kumalo, in paragraph 8.4. Accused number 3 called the accused 1, 4, and 5, to outside the vehicle, and they had a meeting. Ntokoziseni, accused number 4, then took out a firearm and gave it to Karos, accused number 3. Muzi, accused number 1, had his firearm. He, that is accused number 2, also had a small firearm that was given to him in the vehicle. Then paragraph 8.5. Karos, accused number 3, said they must all be positioned as they were going to hit SENZO MEYIWA. They all got out of the vehicle, which was driven by Sifiso, accused number 5, to Lieutenant Colonel Rapadu. He says accused number 4 gave a firearm to Karos, accused number 3. Then Muzi, accused number 1, was the lookout. Mapisa, accused number 4, went to stand by the window. The T, that is now accused number 2, and Karos, accused number 3, were supposed to get into the house. When they got into the house, he, that is now Karos, pulled out a firearm, ordered everyone to lie down, and demanded money and a cell phone. In the confession to Lieutenant Colonel Rapadu, he said that Karos, that is now accused number 3, shouted in isiZulu, "Panzi, Mali, ne ma cell phone," close quotations. And the court will remember that's exactly what the witnesses who were in the house testified. So what he says in what number 2 says in his confession, my lord, accords with the evidence of the people who were in the house. Once again, that demonstrates the high degree of probity of the confessions. Then Karos, accused number 3, gave him a phone and a plastic bag with money. We know that cell phone belonging to Ms. Kelly Kumalo was robbed. Hence, there is a charge that pertains to that.
None of my business. I don't have hopes for rubbish. I have no hopes for rubbish. I'm sorry. I said what I said.
In the words of Kelly, I have no interest in rubbish. But basically, Baloyi is outlining the confession of Ntanzi, why it is accurate. I mean, it is backed up by his manager who came to court to confirm that yes, he was at work on that day. So how would the confession be a lie if it has such accurate information? So my lord, Bongani Ntanzi is a very credible witness. Now here's my question to Advocate George Baloyi. So Kelly Kumalo's cell phone was taken by these intruders, but she has never visited the court to tell us about that ordeal, that horrible ordeal for her. Yet she is the owner of the cell phone. And then on the other side, she is the mastermind in the same confession. In the same confession, she is the one who hired the 5 accused for a hit. Make it make sense? Make it make sense, my lord. You can already see in the same confession, if we're going to go by Advocate Baloyi's arguments, in the same confession, one cannot be a mastermind and then their cell phone also disappears. It just doesn't make logical sense. But let's continue listening on, because the evidence in Mnisi's words is struggling.
To the confession to Lieutenant Colonel Rapadu, he says that he's the one who collected money and cell phones. So once again, my lord, this accords with the objective facts, and we have heard the evidence of Ms. Pinky Fathillingham, which shows that the cell phone that was robbed made contact with Muleleki Tower. 8.6 says Senzo stood up to Rapadu. He said Senzo jumped at Karos, and there was a scuffle between him and Karos, that is accused number 3. We know, my lord, all the witnesses have testified that there was a scuffle. How could accused number 2 have known about this fact if he himself was not in the house? So once again, my lord, we see the safeguard as to the reliability of his confession. It says Kairos, that's accused number 3, fired 2 shots. This once again accords with the evidence of the ballistic expert, Lieutenant Colonel Mangena. The second shot hit Senzo, but he did not see where Senzo was hit. He, that is accused number 2, left the house as Senzo was falling, and he ran out of the house to the car. He says when he ran out of the house, Mtokosizeni Mapisa, that is now accused number 4, came in. They, that is accused 3 and 4, remained in the house. Muzi, accused number 1, was standing outside. And when we deal with the evidence of Makaleni, we'll just briefly touch on that. It says they all came back. That accused number 1, Muzi, was in front. Mtokosizeni Mapisa, accused number 4, and Karos, accused number 3, behind him. They drove away from the scene and drove to the hostel and went into a room. Mtokosizeni, accused number 4, asked Karos, accused number 3, "Are you sure you hit him?" Then Karos, accused number 3, and Sifiso, accused number 5, ordered him to go to the kitchen, and the 4 of them remained in the room. Sifiso later came out and gave him 15,000 rand. After 2 days, Sifiso, accused number 5, gave him additional money. In total, he got 45,000 rand. Paragraph 8.7. We mention once again that accused number 2 made the second confession statement on 24 June 2020 to a magistrate in the presence of his attorney. And, my lord, we did mention during the course of the state case, during the course of Brigadier Gininda's evidence, that the defense themselves elicited the fact that there was a Section 105A proposal. This is a plea and sentence agreement.
Is that evidence admissible?
Well, it is not admissible, my lord, but they elicited it.
No, I understand, but I'm saying
Yes,
for
yes.
judicial purposes.
Yes, no, it is not, my lord. We
not.
just mention it en passant, that they did elicit that despite the several warnings that we sounded to them, they persisted with that line of cross-examination. But we agree, my lord, that it's hence we...
Except that the court can possibly take note
Yes, yes.
of the allegations, and
Yes.
I'm not making a finding, of the evidence of Gininda,
Yes.
saying that Mr. Mjiako was busy consulting with you guys, with the possibility
yes,
of
yes,
the
yes.
settlement. He said that.
Yes, he did mention.
Yeah, no, I'm just saying.
Yes,
You mustn't say I'm inventing the evidence.
yes.
One thing I can tell you about Baloyi, he does not play games, okay? He does not play fair, okay? He knew very well. So he's reading, talking about Ntanzi'S statement. He's giving all the details, okay? After the analyzing, they went back to the room. Bongani Ntanzi got 15K, and after that, he got more money 2 days later. It added up to 45K. He's flowing, okay? He's going. And then he pauses, okay? And then he says, yeah, we want to pause at this point, my lord, to say the accused, the defense team, we told them not to mention it in the court, but they brought it up. And I told them not to mention it. The Section 105 agreement. And my lord says, yeah, but it's not admissible. And Baloyi says, yes, we know it's not admissible. Ladies and gentlemen, if he knew it's not admissible, why is he even mentioning it? He's mentioning it because he wants to make sure it's part of recent memory of my lord. In case my lord decided to strike it off the record, he's bringing it back up again for recency in memory terms so that my lord remembers that moment, because it's not on record, okay? It's not admissible, but he wants my lord to have that at the back of his head. Sneaky, sneaky. But then what else can you do when your evidence is teka-teking, is struggling? Let's continue listening on.
And Brigadier Gininda said, well, the state said I mustn't testify about this,
fine.
but the more he said that, the more he was cross-examined on that fact. Paragraph 8.8, the version in both confession statements accord with the version of the state on how the incident happened, as we've mentioned, how it was planned at the hostel, as testified to by Constable Sizuzungu, the day and time when it took place, how it happened, namely the two persons entered the house of the Kumalos on the date and time, and how he and the accused were present. The accused three entered the house, and the latter demanded money and a cell phone in isiZulu. And as we've indicated, this is what the witnesses who were in the house mentioned. Paragraph 8.12. Ms. Zandi Kumalo and Tumelo Madlala identified accused number 2 as one of the two persons who entered the house, and accused number 2 in his confession admits that he was in the house. The witnesses who were in the house testified that the gun-wielding attacker who was in the house had dreadlocks on, and accused number 3 had dreadlocks at the time. It's a fact that hasn't been disputed, as we have seen in Exhibit S. Paragraph 8.13, accused number 2 states in his confession that there was a scuffle between the deceased and the dreadlocked attacker. The witness testified about that. Paragraph 8.14, accused number 2 states in his confession that 2 shots were fired in the house, and the second shot struck SENZO. The witnesses who were in the house testified to this effect, including the ballistic expert. And as we debated earlier on, my lord, that even the pathologist, Dr. Steenekamp, testified about this fact that this was a contact shot. 8.15, accused number 4 states in his confession that SENZO was shot during the struggle.
Not number 4.
No, accused number 2 states in his confession,
fine.
in his confessions, that SENZO was shot during the struggle with accused number 3. The ballistic expert and pathologist confirmed that the deceased sustained a contact shot wound. Paragraph 8.16. Accused number 2 mentions in his confessions that he was with accused number 1, 3, 4, and 5 during the incident. Then accused number 1 made a confession and pointing out the house of the Kumalos and where they were dropped off near the hostel. Accused number 1 stated in his confession that they consulted a traditional healer before they committed the crime, and afterwards went back to the traditional healer for cleansing. The traditional healer, Mr. Lionel Zwani, testified that accused number 1 indeed came to see him in the company of other two persons whose face he couldn't see.
So, this next part is going to catch you off guard, but I want you to keep in mind that I am speaking purely based on what Baloyi is putting on the record, and I'm just breaking it down. Remember, Ngumalo spoke about the doctrine of common purpose the other day, and he spoke about the Ngedezi decision, which says the accused must have been present at the scene, aware of the attack, intention to make common purpose, common cause with the participants, and active association with the attack, and also the intention to kill or contribute to SENZO MEYIWA's death. Based on the confession that Baloyi read, so think about it. In English class, you're asked to write, a story, you're given the storyline, and then you're asked who, what, when, and how. This is literally the confession of Bongani Ntanzi answers the doctrine of common purpose requirements. I'm not saying the confession is correct. I am saying the confession answers those things, and that is what Baloyi has been preaching over here in his readings. I pause because this is the reason why my Lord is holding on tight to the confessions and doesn't want to let them go. Ngumalo also spoke about there must be a close proximity, significant and not limited participation. Bongani Ntanzi's confession puts all of them there at the Spaza house in close proximity. That's why one is by the window, one is outside, two of them are inside, and then accused. The one who's not close proximity literally is accused number 5 in the vehicle. Could that be the reason Shololo is going ahead with no 174 application? I don't know. But remember, my feedback is purely based on the law, what the law states, and what these confessions were doctored to do in terms of meeting the requirements of the law. Kuningi, guys. Kuningi. Let me end this here. I don't want to drag this out. I want to let you all process this. Let me know your thoughts in the comment section down below, per usual. Thanks for watching. I know this is going to be a tough one. I am not endorsing the confession. I am not saying the confession was taken freely and fairly. I am saying this is the struggle evidence, and this is what that struggling evidence does when it's tied with the law. I'll catch you on the next upload.